Hey everybody, welcome into the back room. I'm Andy Ostroy. We have attorneys and former federal prosecutors Tim Heaphy and David Harbach with us today. We'll chat with them in just a moment, but first, thanks for tuning in. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and or post on our social media, and we'll read some feedback next time. And if you like the podcast, please rate and review and follow or subscribe, and you'll be notified every time we post a new episode. So Tim Heaphy is a former federal prosecutor and founding partner of the new law firm Heaphy Smith Harbach Windom. He has extensive experience in complex investigations, white-collar litigation, crisis management, and compliance counseling developed in public service, in-house, and private law firm practice. His clients include corporations across a wide variety of industries, universities, and public entities facing federal investigations, investigative challenges, and business and reputational crises. He was also the chief investigative counsel for the House Select Committee investigating the January 6th attack at the U.S. Capitol. He is regularly called upon by major media outlets to provide insight and analysis on significant legal issues. David Harbach is also a founding partner of the new law firm Heaphy Smith Harbach Windom, and most recently served as an Assistant Special Counsel in the Office of Special Counsel Jack Smith. His 21 years of service as a prosecutor include tours in the U.S. Attorney's offices for the Southern District of New York and the Eastern District of Virginia, the Public Integrity Section of the Department of Justice, the Harris County District Attorney's Office in Houston, Texas, and as an international war crimes prosecutor in The Hague. He also served a one-year detail as special counsel in the office of FBI Director James Comey from 2014 to 2015. He has tried dozens of cases to juries in courts across the country and is a fellow of the American College of Trial Lawyers. David, Tim, welcome into the back room.
Thanks, Andy. Good to be here.
Likewise.
So you guys just started a new law firm, Heaphy Smith Harbach Windom. Congratulations on that. You started with former Special Counsel Jack Smith and Thomas Windom. Why start a new firm now? And tell us a little bit about the type of clients and cases you'll be focusing on.
Yeah, look, all of us have similar backgrounds. We're all former prosecutors. We sort of learned how to practice law in the Department of Justice. And this is a period in our history in which lawyers faithful to the proud tradition of that place, fidelity to the rule of law, to following the facts and the law wherever they lead, sort of more important than ever. And as I spoke to Jack about his plans post special counsel, he connected me to Dave, with whom I never worked. I'd actually never worked with either Dave nor Jack before. I'd known Thomas Windom for a period of time, but all of us were sort of similarly thinking about how our respective backgrounds would inform the current moment, and we decided to join forces and start the law firm. So we've been in business for just a few weeks. Very, very excited about the horizons that lay ahead.
How's it going?
Well, it's going well. We were fortunate to have a couple of associates join us right out of the gate. So we're 6 lawyers total. We've probably unsurprisingly got a fair amount of interest just from the announcement of the firm. People reaching out to us for representation of one form or another. We are working together to try and discern what matters we should take and what matters we shouldn't take. But an important thing to remember, Andy, is that our Constitution is not just an anti-Trump firm in any way. It's understandable why people might surmise that that's what's going on here, but it really isn't. That's not our main focus. Of course, we're willing to take clients who are, for whatever reason, interested in taking on the administration or have been wronged by them, but that is not our reason for being. We are a full-service firm. We plan on servicing all sorts of clients, corporations, institutions, public and private, individuals, for a range of services, but primarily litigation and investigations. We do have a bit of a subspecialty, thanks to my friend here, Tim Heaphy, and his particular expertise in the area of education law and his experience counseling a major university, the University of Virginia. And so we are hoping to make the most of that marketing opportunity also.
Have you seen a lot of press or criticism, especially coming from the right, about it being an anti-Trump law firm, to use that term?
I mean, Tim can speak for himself. I haven't seen a whole lot of that, to be honest. Now, to be clear, ever since we've been asked about this by you or any journalist, we've made clear that that's not our MO.
Right.
But understandably, I think we were curious about what reaction that might provoke, but there really hasn't been any that I've seen.
Mm-hmm. And, you know, the reality is, because you're partners with Jack Smith, that's probably 98% of the press, good or bad. And so I wanted to ask you guys, Smith is such a political Rorschach test, if you will. How do you navigate partnering with someone so widely praised and demonized at the same time, and who has a giant target on his back from an obsessed Donald Trump?
Can I go first on this one, Tim?
Please do. Yeah, I'll chime in.
I'm going to go first, or asked to go first, just because I've known Jack quite a long time, Andy, and so I've known him, well, to put a figure on it, I've known him since April of 2010. That's when I first started working with him. And a lot of the stuff that you're talking about, the Rorschach test nature of him and public perception of him, to me, someone who's known him for 15 plus years, that's all noise. Mm-hmm. Jack, from the very first case I ever presented to him as a line prosecutor, has been a nonpartisan. And when you work at the public integrity section, like I did and like Jack did, you get used to every single case, if it involves a public figure, whether it's a D or an R or somewhere in between, kicking and screaming that the investigation into them is a political witch hunt. So it doesn't matter what side of the aisle you're on. That's the common refrain. I mention that to say that in my time working for Jack, when he was chief of public integrity, most especially, I never knew what his politics were. And I never for one second thought that politics informed a decision he made on any case, any investigation, any target. And that was true whether it was an R or a D. So to circle back around to your question, my personal relationship with him exists independent of any of the noise that's circulating around. And my decision to work at a law firm with him is based on, number one, his character, which I know to be outstanding, his quality as a lawyer, and which is also outstanding. He has a tactical mind unlike just about any other that I've known. And, my personal friendship with him. All those three things make it easy to be a partner in a law firm with him. So that's my 2 cents.
Mm-hmm.
Yeah, and Andy, look, I think this cuts in both ways. Frankly, in terms of a business development matter, there certainly will be clients that, because of Jack and the rest of us being, enemies of the state, so to speak, with the president of the United States tweeting that, my partner is a deranged criminal, there will be clients that shy away from us for that reason. But I think there are just as many or more clients mm-hmm. who will be attracted to us because that's noise, as Dave said. We are unafraid to take on the administration in matters large and small. We have demonstrated throughout the course of our public service, and we will again in our private practice, that we are here to fight. If the client needs a fighter, we are here and prepared to do that. So it is sort of 6 of one, half dozen of another. Again, I think there's a lot of pent-up demand in the marketplace for lawyers of integrity who will take the case to whatever level of contention, whatever courtroom, whatever conference room it requires. And we're in that category. I'm hopeful that leads to tangible opportunities for the firm.
Mm-hmm. Fast forward 5 years, what do you hope people say this new firm stood for during a period when the rule of law felt so genuinely at risk?
Yeah, that's a really good question, and it's one we've talked about. First of all, we want to build something that outlasts the current moment, that has roots and branches that extend beyond today, right? We want to establish a firm that will be known for doing quality work indefinitely into the future. But look, over the next 3 years, there will be many moments in which lawyers need to stand up. Lawyers need to be prepared to defend the rule of law, who need to go to courts, state and federal, around the country and challenge executive overreach or defend people that have been unfairly maligned. And we want to be on that side of history, frankly. My hope is that we will, in 5 years, be proud that we have done our part to be sort of guardrails of democracy, that we've helped clients achieve goals despite headwinds that they face from the administration. But to be clear, as Dave said before, our aspiration is much, much bigger than the short-term imperative to take on this administration.
So let's talk about that overreach for a little bit. Where do you think Donald Trump this past year most clearly crossed from aggressive politics into autocratic, illegal, unconstitutional behavior?
Well, I'll start with where we all grew up as lawyers, the Department of Justice. I'll tell you a quick story, Andy, that when I was a presidentially appointed United States attorney in 2009, I had a chance, once I was confirmed by the Senate, unanimously confirmed by Republicans and Democrats in the Senate, to go to the White House and meet with President Obama, who had appointed me. And he said to me and the other assembled, recently confirmed U.S. attorneys, "You're not my lawyers. I don't want you for a minute to stop and think, when you're making a decision about a case, about a matter in your district, hey, what's best for Obama or what's best for the administration? You should do what's best in your judgment for the people of your district." And that was the proud tradition of the department, regardless of whether it was a Democratic president or a Democratic attorney general or a Republican president or attorney general. I've served under both. And that was just how we rolled, right? That was the assumption. And I don't think that's any longer the assumption. What we've seen is conversely a Department of Justice that believes that they are the president's lawyers, that they are there to do his bidding, that they sometimes seemingly take direction from him. Some of the retributive prosecutions or frankly, the failures to investigate things that would be against his political interests, the termination of career prosecutors and FBI agents for no reason other than the work that they were assigned to do. That's just anathema to the history of the place, regardless of Democrats or Republicans. And that's frankly troubling, right? That separation between the White House and the Justice Department historically has been really important to protect the rule of law. And the evisceration of that, or the attempted evisceration of that, to me stands out as among the most serious threats we've seen.
Yeah, Donald Trump has, on many occasions, infamously said, "I want my Roy Cohn. Where's my Roy Cohn?" And he got his Roy Cohn. Unfortunately, she happens to be the Attorney General of the United States. And to your point, and to what Obama said to you, she doesn't, and her department does not represent the United States and the American people. It is clearly representing Donald Trump. And that is pretty chilling.
Yeah, absolutely. Look, the president's entitled to have advisors who protect him, his personal counsel. But the Attorney General represents the people of the United States. Like when I was an assistant U.S. attorney, when I went into court every day, I said, "I'm Tim Heaphy here for the United States." I didn't say I'm Tim Heaphy here for Barack Obama or George Bush. I represent the greater cause of justice. That is a heady responsibility that we took seriously. And again, I fear that current assistant U.S. attorneys are not held to that standard, but they're held to a different standard of personal fidelity to this president.
If I could just add a point there that I know Tim agrees with. Just a word about the career public servants who remain at the department. Many of them have left for various reasons, but there are still many people still at the department who know a DOJ the way it was when Tim and I worked there, and the way it's supposed to be, and for my 2 cents, the way I think it will be again eventually. But those people, and Tim and I both know folks in this category, they're struggling right now. They're struggling with their morale. They're struggling with their sense of duty and their obligation to do their job as best they can on behalf of the American people and try to handle each case that's in front of them the best way they know how. For folks on the line, they may be able to some degree to put blinders on and say, okay, I have to focus on this robbery case that I'm doing, and I've got to turn all this other stuff off. They can do that, but that's corrosive over time. And so I don't know. I think about those folks a lot, and I'm grateful, first of all, that they remain at the department and that they continue to do the job that they've been sworn to do. And those are folks who do it not for any public recognition at all. They do it because they enjoy it, and that's what they're sworn to do.
But are they able to do their job the way they signed up to do it and the way they should be doing it, given the orders that come? I mean, we've seen, Trump through his social media posting literally order Bondi to go after this opponent or that opponent. And when she just seems so corrupted, almost like a spokesperson, she doesn't even, he got his Roy Cohn and a publicist all rolled into one. Can they do their jobs effectively, or are they going to end up resigning as well at some point?
Well, I think the answer is it depends. I mean, I think there are obviously high-profile investigations and the like that get attention of folks like you and others in the press. Sorry, I just kicked my desk. On cases for which influence like that, or posturing like that, or directives like the ones you're talking about can be debilitating and can prevent people from doing their job. And I think in some of those cases, you've seen resignations. But all I'm trying to point out is that there is a huge swath of cases of work that is being done still at the department that is below the radar, if you will. I only mean that to say that the press doesn't really pay attention to it. It's not to diminish the work's importance at all. And it's hard for me to say, not being there right now, how much the larger morale damaging conduct affects those people in their day-to-day. So I'm guessing, but my guess is that at some level in their consciousness, it hurts and makes it hard. But the people I have in mind who are dedicated public servants are going to do their job the right way anyway. And if they can handle their cases the right way without anybody noticing or without anybody interfering with what they do, then that's what they'll do. And that's what we want from the career public servants who are still there.
Yeah. Another issue is what the New York Times reported yesterday is that recruitment is really suffering. Justice can't find the amount of and quality of people to join the department because of loyalty oaths and all kinds of craziness like that. How big of a problem is that going forward?
I think it's a tremendous problem. Look, it is a sacrifice, financial and practical, to be in AUSA.
Right.
You make relatively little money, certainly a lot less than you could make at a private law firm. The job can be very intense, very demanding, emotionally and practically. I had 3 children during the time that I was an assistant U.S. attorney. Each of them was born during a time when I had to very quickly rush to the hospital and then go back to court. I mean, it's just, you make a huge personal sacrifice. So in order to make the sacrifice, it has to be meaningful and be prestigious and stand for something. And I think what's happening now is that there are a lot of lawyers that are not willing to make the sacrifice because they don't want to stand for this loyalty, right? This priority, which is on the president's priorities. I think I saw something recently where there was a tweet or something that was posted publicly, essentially encouraging people to apply to the Department of Justice to pursue the president's priorities. Like it was an explicit, it's like said the quiet part out loud. It's like, we want lawyers who are going to pursue the president's goals. Again, that's not the job. The job is the people's goals, what's best for the people, following the facts and the law, not a political agenda. So when people see that, they realize, hey, I'm going to make the sacrifice, not for this high-minded concept of the rule of law and doing justice, but rather to pursue the political agenda of the president. Now, there are some people willing to do that, but they're not necessarily the same There aren't as many of them, or frankly, the same caliber as the historic quality of lawyers that have come through the Department of Justice.
Andy, before we move on to a different topic, I just want to maybe put a finer point on this discussion. I mean, Tim and I both made the point that we served for U.S. attorneys at different administrations and different parties in the White House. But I can maybe even bring it to a little more granular level. I have served as an assistant district attorney in the state system in Texas, and I've served as an assistant U.S. attorney in multiple U.S. attorneys' offices, and I've served at Main Justice. And in all of that experience as a prosecutor, state and federal, in all of the cases that I've done, not a single time, not ever, has the elected district attorney or the sitting U.S. attorney put any pressure on me ever, one way or the other, on any case. Never come in my office and close the door and say, "Hey, we really need to get this guy, Harbach. Let's throw the book at this guy." Never. Or, "Hey, do you mind kind of backing off so-and-so a little bit because just would be for the best." Like, nothing like that has ever happened to me. And dollars to donuts, just about any career prosecutor in any U.S. attorney's office is going to tell you the same thing. So it's not just this abject, whose team are you on, R or D, and we don't care. That's not part of the program. Right. That's not the way righteous and ethical prosecutors practice. It doesn't happen.
Yeah, no, politics is not supposed to have anything to do with the law. You mentioned the high-profile cases before. Trump has clearly been abusing his power by ordering Bondi and the Justice Department to investigate and indict his opponents and perceived enemies, people like Tish James, James Comey, John Bolton, Senators Adam Schiff and Mark Kelly, Minneapolis Mayor Jacob Frey, and Minnesota Governor Tim Walz, and Don Lemon, with the exception, perhaps, of Bolton, which seems a little bit more complicated. Are these just bogus witch hunts that will go nowhere?
Look, thankfully, the president has to plug those cases into an existing system, a system that does still afford due process. The Comey case, great example. His very capable lawyers immediately moved to dismiss that case because of grand jury misconduct, and they were successful. That case is no longer pending. I think those are examples of what I have seen beyond the Department of Justice, of actions taken by the executive that are almost on their face patently unlawful, that they don't care. They know that there's a chance that they will lose in litigation over this executive order or this indictment, but it's meant to send a message. It's meant to convey disapproval and, frankly, intimidate other people. I mean, I do a lot of work for universities, for example, and executive orders on transgender care or on DEI programs. The president can't, with the stroke of a pen, change the law. All the president can do is express a preference, but judges over the years have interpreted Title VI and Title IX and what those standards mean. So just by saying, hey, if you pursue DEI programs, that it means you're going to lose federal funds, that has been subject to litigation, and people in universities have gone to court and have challenged that and have been successful. But it doesn't matter if they lose, because lots of other people didn't go to court, but in order to avoid the fight, they've complied and they've pulled back from those programs, even beyond what the law requires. Where I've served as general counsel of the University of Virginia, signed a resolution agreement with the Department of Justice that essentially agrees to comport with policy guidance from Attorney General Bondi that, in my view, far exceeds what the law requires. It's not against the law to pursue a diverse student body or a diverse faculty, diversity of experience and ideology. And this administration is sort of dictating a policy result beyond what the law requires. But UVA said, hey, we don't want to fight. We don't want to jeopardize our funding. So they agreed, and that happens consistently. So it isn't just about the overreach or the action that's taken that won't stand up legally. It's the effect that has on others.
This is a good point you're raising, because starting with about a year ago, we started to see all sorts of capitulation from universities, from law firms, from media companies, it's hard to uphold the rule of law and live in a democracy when those who have the ability to use the judicial system and fight back don't. Where do you see things today versus when we were experiencing the height of that, let's say last early spring or whatever? And are you seeing more or sensing more of an opportunity to push back, a willingness to push back, particularly with clients you work with in the university space or with major law firms? I mean, things on some level seem to have quieted a bit, but I'm not sure that under the surface anything's really changed. Have things changed at all?
Yeah, look, I think that's hard to give you a generalized answer. I think it depends. I'll give you the lawyerly answer. It depends on the client. It depends on the university or the law firm.
Right.
The fact that some of these executive orders or executive actions have been essentially ruled unlawful by courts, right? The Wilmer Hale case or the Perkins Coie case, the law firms that have resisted these executive orders have been successful, and that does give certain others, frankly, more strength to say no. Similarly, the Harvard case really matters with respect to universities, right? There's the sort of biggest, most well-endowed, prestigious organization that is pushing back and in court saying it violates due process, it violates free speech for you to threaten our federal funds based on allegations of alleged anti-Semitism or things that are disconnected from the funding. So success in those cases does strengthen others. That said, I still think across industries, you name three of them, media, higher education, and big law firms, there is still a fear of taking a position that will draw scrutiny and potentially lead to that confrontation. A lot of people are making business decisions, practical decisions that, hey, it's better for us, even if we could fight and win because of Harvard or because of Perkins Coie, better for us not to stay under the radar, serve our clients, or keep our federal funding and keep going. So, we'll see over time. I mean, there was sort of this burst of energy about law firms, not anything else in a long time. There's this burst of energy about universities that has quieted down. So it may be that intimidation, that sort of shot across the bow has been fired, and there aren't going to be subsequent shots. And over time, the further away from the shot you get, the more emboldened people are. That's just kind of too early to tell, Andy. I think we will see going forward. That's a very individualized decision in my experience working with clients.
Mm-hmm. One of the things that people have noticed in the last week or so is we've seen a lot less of Pam Bondi and a lot more of Deputy AG Todd Blanche. Have you noticed the same thing? And if so, is there anything to make of that?
I don't know. It seems like the deputy has been more visible lately, but to try to get in the heads of them or the president is a fool's errand. I can't frankly give you a rational assessment as to what that means or doesn't mean.
Mm-hmm. Same.
Okay. What are your thoughts on Bill and Hillary Clinton being forced to testify before the House Oversight Committee in the Epstein hearings? And more specifically, this is a really interesting precedent that's going to be set, correct?
Yeah, it's very rare for a former president to be compelled to testify before Congress about anything. I believe that President Clinton's lawyers have cited that precedent, and it was not persuasive. I haven't seen anything in the Epstein files that would suggest that either the president or Secretary Clinton have done anything wrong, like legally wrong. So I don't anticipate that there will be any bombshell new fact coming out of this testimony. Others, Attorney General Barr and Attorney General Holder and others have gone before Congress and provided information about their recollection of the Epstein investigations. And I assume similar questions will be asked to President Clinton. Secretary Clinton, I have a harder time. I mean, there's sort of documents that suggest that President Clinton did spend some time with Mr. Epstein. Understandably, that would be something that Congress would want to ask about. Secretary Clinton, though, I'm not an expert on this, but I haven't seen as much about her personal connection to him or the facts surrounding that matter. So that one seems a little bit more of a reach to me. And then the last thing I'll say on this is that there's no question that a lot of people on both sides of the aisle are trying to use the Epstein files for their own political gain. And the House Oversight Committee hauling Bill and Hillary Clinton before them to grill them about Jeffrey Epstein undoubtedly has a political goal more than a substantive goal. Again, I don't expect new facts that are relevant to an ongoing investigation to arise, but it is, again, it's like, hey, we're in charge, we can do this. And there's this sort of an intent to pull them into this, to tarnish them by reputation that frankly, on this issue, both sides are doing.
Yeah. So for all intents and purposes, back to Trump's autocratic overreach, is he essentially acting as if he's above the law? Have we reached that stage yet, which was what a lot of people had feared? Or do you think the guardrails of the judicial system are, for the most part, preventing him from truly being above the law at this point?
Yeah, I guess my view on that is to be determined. There are certainly actions that have been taken or attempted to be taken that seem to be clear overreach, that clearly extend beyond what executive authority, how executive authority has been defined in the past. There have also been very serious backlash against that, both legally and politically, and that matters. So I think the jury's still out as to whether or not we have or haven't crossed the line. I mean, their adherence to the judgments of the courts is a big one. And I mean, if the president were to say, hey, I'm a co-equal branch of government and I disagree with what this district judge or that court of appeals or this Supreme Court has determined to be the law, that would be a constitutional crisis and a new frontier. There have been, we've been close to that line. I don't think that we have gone over it at this point, but that's really, again, TBD. And thankfully, there has been a lot of energy opposing this and a lot of success in court. Judges who have said, no, it's not okay to detain American citizens based on their ethnicity, or it's not okay to override the wishes of the local authority and bring the National Guard into. I mean, there have been successes that have prevented more overreach, and I think you'll continue to see a lot of litigation over a lot of what the president wants to do that stretches, again, the bounds of what we've understood as executive power.
Yeah, I mean, the lower courts, to your point, have done a really good job keeping him in check. And what's happened in more than one or two occasions is we see the language from the judges in their rulings, like excoriating Trump and the administration. How unusual is that, and how telling is that from a legal standpoint when a judge goes so far beyond just issuing a ruling and literally starts to thrash one of the interested parties?
Well, I for my part, I'll say that I think judges are human. And to the point that Tim was making a moment ago, on the larger question of the guardrails, maybe I'm a little more optimistic, or some people might call me naive, but I have a lot of faith in the institution of the judicial system. Mm-hmm. I think that it is functioning as it's meant to function in dealing with these cases of potential overreach or de facto overreach. But judges are human. And, when you have a situation where a lawyer representing the United States, remember what Tim said earlier, that's the client, goes into court and makes a misrepresentation or, is so obviously dodging the court's questions as to not want to give the court a direct answer. That's very frustrating. It will be frustrating for anyone. It's especially frustrating for, an Article III judge. So I think the judges who have penned opinions that are maybe a little fiery or a little more frustrated than ones they're used to doing in the past, I don't think that's political theater. I don't think it's shtick. I think it's genuine frustration by a jurist who either can't get an answer or doesn't have the same trust and faith and is not willing to give the same credit to a lawyer for the government that he or she has been used to giving for many, many years. And that in itself is probably frustrating for judges. So my personal view is I don't think there's anything to read into it more than that. But that's significant because, frustrating a judge is not a good thing to do.
And on the judge's point, Andy, I'll just add to what I agree with everything Dave said. It always kind of bothers me when I hear a judge referred to as a Trump judge or a Biden.
So true. So true.
Just because President X appointed this judge doesn't make that judge a partisan. Quite the opposite. In my experience, judges appointed by Republican presidents or Democratic presidents try to get it right and are faithful to the rule of law. There are of course exceptions, but generally the men and women who wear that robe try very hard to get it right. I spent a lot of time as a lawyer in Washington, D.C. in front of Judge Royce Lamberth, who was a Reagan appointee, known as a very conservative guy. And he has recently written opinions about the rights of transgender prisoners within the Bureau of Prisons to be segregated for their safety, to obtain transgender medical care. This is not a political motivation for conservative Judge Royce Lamberth, who has immense respect across the political spectrum in Washington, D.C. He's been a judge for 30, 40 years. He was, again, appointed by President Reagan. So you're seeing, and the press is surprised, well, conservative Reagan judge is taking this, and I'm never surprised because, again, he's just applying the facts and the law in front of them. So plenty of judges appointed by Donald Trump in his first term have been among those that have ruled that some of the actions he has taken is an overreach. And that's not a surprise to me. That's the way it's supposed to work.
I completely agree. I'll echo what Tim said. I've heard judges complain, in public addresses or not, about feeling like any time their name appears in the paper, it's like an inevitable appendage, a blank appointee,
right,
by whatever president they were appointed by. I mean, and I think Tim is just right on this assessment. I also think that it's frustrating for me the degree to which our public discourse, I mean, it's almost trite to say it's polarized now because it's, that's been the case for so many years now. But it's almost as though everything has to be viewed through that lens. Mm-hmm. You start reading an editorial or an op-ed in the paper, and you might read the first sentence before you look to see who wrote it, before you go any further. Or the analog with judicial opinions is, oh, well, who wrote this? Oh, is that person a Trump appointee or a Reagan appointee or a Bush appointee or an Obama appointee? It's just unfortunate, especially in the legal field, because it's the whole point. The law is the law. When we talk about the rule of law, we mean that it gets analyzed and assessed and applied faithfully, irrespective of one's partisanship. So I understand why judges get frustrated that they get rammed into these red or blue boxes just like the rest of us. It's unfortunate, and it's not borne out by experience. I agree with Tim on that too.
Yeah, well, it's an insult to their integrity, whether it's the president or certain members of the media who do that. But you're right. That's the toxic landscape, partisan landscape we're living in right now.
And it's almost as though an opinion only, I don't want to say only has credibility, but it's like it gets bonus credibility if the partisanship doesn't line up the way you think it was. It was like, a D, ruled against President Obama. Ooh, that must be an honest opinion. I mean, it's just nonsense.
It is nonsense, and it's something we've never seen before, ever. One of the things we're all waiting for is this Supreme Court ruling on tariffs. A couple of months ago, when the hearing took place, we did get a sense that the justices overwhelmingly were not siding with Trump on this issue. But it will be an interesting ruling when it comes. I'm sort of curious as to why it hasn't come yet and what, if anything, that might mean, in your opinion. But this is a pretty clear-cut case, isn't it? I mean, we're going to see who the strict constructionists really are, because the Constitution is pretty clear about which branch of government has control over taxes, of which tariffs are taxes. Where do you think this is headed?
Just from the tone of the argument, you're right, Andy. It seemed as if many of the justices were skeptical of the government's view that there's an economic emergency that justifies these tariffs. So to be clear, the argument from the administration is that IEEPA, this statute, which essentially gives the executive authority in an emergency, an economic emergency, to impose levies, taxes, tariffs. There is hard to imagine here on the facts that there is such an economic emergency. And there was very little by way of sort of proffer or evidence from the administration that would justify, hey, we are in a free falling recession or some sort of trade imbalance. I don't even know what it would be. I'm having trouble thinking of what evidence that would justify the invocation of IEEPA to as a support for tariffs. So it is a test. You're exactly right. Look, I hesitate to write off the Supreme Court. I hear some commentators in the press saying, they're in the tank for Trump. I don't think that that's necessarily accurate. I think they do have generally a very robust sense of what is within the authority of the executive. That is not a pro-Trump necessarily position. That's an ideological position. And there are conservative justices that have approved the sort of robust executive authority, and this is along those lines. But you're right. If the Supreme Court comes out and says, IEEPA really doesn't apply, you have exceeded your authority, Mr. President, and these really are the prerogative of Congress, not the executive, that will be seen as a rebuke of President Trump, and it will be, and it'll be seen as by progressives as sort of the Supreme Court finally standing up for the rule of law. Again, I'd hesitate to say that that's motivated by politics as much as it is ideology or the justices' views on what is or isn't an appropriate exercise of executive authority. Your question about why it's taking so long, in my experience, the reason that opinions take a long time to come out is that there are probably several opinions that the justices are circulating. So they voted, and Justice X is going to write the majority opinion, Justices Y and Z are going to write dissents. Before the opinions were published, they have a right to see each other's drafts and incorporate responses into their opinions. That process takes time. So the fact that it's taking a long time suggests that it isn't unanimous, whichever way it goes, that there might very well be multiple opinions. And that is why it's taking some time, because the circulation and incorporation of responses to those various opinions. That would be my guess as to why it hasn't happened yet.
This is sort of a good segue into the next subject I want to talk to you about, which is the upcoming midterm elections and Trump's overall rhetoric, because the courts, especially the Supreme Court, has not done a great job in defending voting rights in the last decade or so. David, you were part of Jack Smith's team in indicting Donald Trump in the classified documents case. Tim, you were lead investigative counsel for the House Select Committee on the January 6th attack. What goes through your minds right now when you see Trump using very similar dangerous rhetoric about the midterms being rigged, about other rhetoric about nationalizing elections? How worrisome is this to you?
Well, personally, I think most Americans don't think that the election system is rigged in the sense that he continues to talk about it. Again, this may be another example of me being naive, but the offhand comment he made the other day about Republicans needing to take over elections. I don't think any of that is going anywhere. Sometimes don't understand why he makes comments that he does, maybe just to be provocative. I don't know, but I don't think there's any realistic chance of that happening. So I guess I don't mean to sound Pollyanna about it, but I don't worry too much about it. It's not to say that the comments aren't troubling coming out of the mouth of the president, but I don't.
I am troubled, Andy, by the search warrant in Fulton County. That we on the Select Committee spent a lot of time working to rebut this notion that there was election fraud in Georgia or anywhere else. And we had testimony from people like Brad Raffensperger and William Barr, who said unequivocally, we looked very hard at Fulton County and found no evidence of systemic fraud sufficient to undermine the outcome. And that has remained the case, the unimpeachable case, ever since the fall of 2020. So I don't think that the affidavit in support of that search warrant has yet been made public. I think I saw something that it will be soon unsealed. I'll be really curious to see what evidence led a federal magistrate judge in the Northern District of Georgia to approve a search warrant for ballots in Fulton County. Because again, a lot of people over a long period of time, people across the spectrum, Republican Secretary of State Raffensperger and President Trump's own Attorney General, have looked very hard at those issues, the issues of integrity of the 2020 election in Fulton County, and found nothing. Mm-hmm. So that does trouble me. And we were talking before about retributive overreach that's directed to settle scores. This has the whiff of that. And I do think on the sort of point of a broader intimidation, even if nothing comes of it, it does potentially affect local election officials or secretaries of state in other places. And it's meant really to be kind of a saber rattle of, hey, we're paying attention. And so it takes evidence actually to thankfully to have legal consequence. And I will be shocked if there is any evidence of election fraud uncovered in that search or even in that affidavit.
Yeah. Well, I guess the real question that a lot of people have, that I have, is like, clearly there's one part of that raid, which is retributive. It's him trying to relitigate something that happened 6 years ago that he can't seem to get out of his head. And then there's the concern about, is it a precursor? Is he laying the groundwork? Is Georgia a test for what he plans to do elsewhere? I tend to fall in the camp that David is in. I don't think that there's an ability for him to, going forward, influence on a state-by-state level the election in a way that could change the results. So I just think this is just more blowhard stuff, maybe distraction from Epstein, distraction from Minneapolis, distraction from his sinking popularity. But, with Trump, it is a fool's errand to ignore, I guess, anything he does like this that could impact an election, especially if it's a close election. I mean, some people say it's going to be a blue wave, but, these days the elections seem to always be won on the margins or lost on the margins. So, I guess it should be a concern, but the issue is how much of a concern or how much of a reality is it? Nobody knows until we see him doing the same thing in, Philadelphia, I guess. How inappropriate was it for DNI Tulsi Gabbard to be at that raid and for Trump to have spoken with the FBI agents who conducted it?
Yeah, again, your second question first. The president speaking with line investigators about a pending matter is shockingly out of, way, way, way out of bounds, and way out of bounds regardless of whether it's been a Republican or Democratic president. The Justice Department used to have a very strong policy that no one in the Justice Department could speak to anyone in the White House about anything other than the Attorney General and the Deputy Attorney General, and then only in limited circumstances. So for the president to reach into case agents who actually are executing a search warrant to talk to them, who knows what the substance was, a pep talk of sorts, who knows, is just shockingly out of bounds and dangerous. Again, the president should not be dictating outcomes or getting involved in any way in those kinds of investigations. So that is extremely unusual. Tulsi Gabbard's presence, she's the director of national security. It suggests that in that affidavit that supported the search warrant, there's some suggestion of foreign malign interference, which again, we looked at on the select committee. Lots of people have looked at it and found no evidence of. Who knows? We will see, I suppose, when that affidavit's unsealed, if there is some sort of national security predicate that would have been anywhere close to within her purview or her jurisdiction as the director of national intelligence. But it's just yet another chapter, Andy, of bizarre and out of nowhere and troubling people appointed by the president stepping in to do his bidding. That's the overall theme here. That's dangerous and inappropriate.
Mm-hmm. With the autocratic overreach from Trump, his overall behavior, do you think he's just an anomaly, or did he expose weakness in the judicial system that was always there?
Well, I mean, I think that, as Tim said earlier, that the jury is still out on the potential weakness of the judicial system. I mean, we've talked through, just in this podcast today, several examples of those guardrails holding pretty firm. The Supreme Court has the case that we talked about earlier still on its docket, and there will be other cases forthcoming where they've yet to rule. So I guess I'm not sure I agree with the premise that there are as many fissures in the judicial system, and it's just a question of whether he created them or exposed them. I'm not sure I see it the same way.
Yeah, this is a classic separation of powers issue. The executive is empowered to launch and pursue investigations and bring criminal prosecutions, but they can't unilaterally find people guilty or invoke the legal consequence. That has to go through a judicial system supervised by judges and rules and ultimately juries. So we've seen the president exploit his control of the Department of Justice to launch search warrants or indictments or initiate executive action, but we haven't seen the corresponding result. The judicial system actually, when it runs its course, resulting in an outcome that actually has a tangible legal negative consequence. Now, I don't mean to minimize the cost of the investigation. There's a tremendous amount of damage done to Jim Comey and to the people in Fulton County because of the fact that they are having to answer to the investigations initiated by the executive, but they still maintain the protection of the rule of law. Thus far, that rule of law has proved durable and strong. My hope is that it continues to.
Yeah, I totally agree. I've said on this podcast a million times that I am not only supportive of the judicial system so far, but given what's been thrown at them, pretty inspired by it. And even with the Supreme Court, I view them, these powerful people with lifetime appointments who have nothing to gain by destroying American democracy and allowing Trump to become a dictator. I see it that there's like two buckets of cases. One is they sit around and they're like, all right, let's give this guy a little bit more leeway, give him some more expanded power that he likes, but we're never going to hand him the keys to the democracy. The complete shredding of the Constitution. And I don't think, the immunity case could be argued that, they pretty much gave him a lot of power there. But I think arguments could be made also that they really didn't understand what the hell they were doing, and the language is really vague, and the intent was certainly not to give him the kind of immunity that he, tried to exploit. So I agree. I think, look at where we are. We're a year later into his first term, and he has lost so many cases, consequential cases. And I know you guys are not here for the political, but just a point to be made, about the survival of our democracy. It's hard to argue that our democracy is dead when, 2 weeks ago, Democrats flip a state Senate seat in Texas. If democracy was dead, that would not be happening. So I try to tell people, let's separate the rhetoric from the reality, because otherwise you're just going to walk around like Chicken Little all day long, and you're going to drive yourself crazy and drive everybody around you crazy.
Yeah. And Andy, look, I'm an optimist like you, and my benign spin on this is that what happens is that a lot of the crazy overreach prompts a much more powerful response, right? In my view, the bigger threat to democracy is apathy more than...
Absolutely.
Right? Democracy suffers when people disengage and they don't pay attention and they don't vote. That's harder and harder to do when we're seeing American citizens shot and killed by federal agents in Minneapolis and 5-year-old boys detained. And, I could go on about the litany of things. I think what that might be doing in America is creating more engagement, more participation. Look, I think where democracy's fine if everybody in America pays attention, if everybody in America educates themselves, if everybody in America listens to each other, people across the political spectrum, we're going to be okay, right? And maybe what's happening is prompting more of that, more engagement. And that ultimately leads us to a better place. Martin Luther King and President Obama would say, the arc of history, it bends toward justice. It may be a little jagged and it needs to be pushed, but generally over time, it moves in the right direction. I hope that this is an anomalous, jagged step backward, but it leads to a more powerful backlash that protects us all.
Yeah. I could talk to you guys for hours, but we're running out of time. And I got one last question about Epstein. A couple of months ago, there was the Epstein Transparency Act, which forced the Department of Justice to release the full files. We now know that not only have they released maybe half of what they have, apparently there's still 3 million documents, photos, videos, et cetera, still available. But they've redacted the names of the guilty. They have not done a great job of redacting the names of the survivors. And essentially, they've broken the law. There's a law that passed that they're not, adhering to. What happens next from a legal standpoint? Is that it? Is it like, okay, the Department of Justice breaks the law, there's no consequence?
Yeah, I don't know exactly what happens next. Again, we're in a little bit of uncharted territory. There was a law passed by Congress that required full production of this with redactions appropriately for victims' names. It's unclear to me if they have fully complied with that. It seems as if perhaps not. Then I think Congress will investigate that, and there could be contempt referrals. Again, if an executive agent or agency does not abide by the rules that apply, then the remedy for that is contempt, criminal contempt.
But those contempt referrals go where?
To the executive. And again, it's circular and difficult because, like many things, Andy, we're kind of walking on snow with no footprints here. We're going to see where they lead.
Yeah. Guys, this is a great conversation. I hope you'll come back and chat with me again. And good luck with the firm. Wish you much success.
Thanks for having us, Andy.
Really enjoyed it.
Yeah.
All righty. Take care. This episode was produced and edited by me, Andy Ostroy. It was co-produced by Maddie Rosenberg and Jen Hammoud for Radio Free Rhinecliff, with additional editing by Maddie Rosenberg, music by Andrew Hollander, and graphic design by Cricket Langell. And with a special thanks to our sponsor, The Epicurean. Again, thanks for listening. Please rate and review wherever you get your podcasts, and subscribe to the Backroom with Andy Ostroy YouTube channel, where you can watch full videos of our interviews. See you next time.